Take a look. This is 43-year-old Robert Kawada was in court today charged with attempted poisoning, assault and battery with a dangerous weapon on a pregnant person, and assault and battery on a household or family member. Kawada is accused of lying to his ex-girlfriend to get her to take medications to end her pregnancy. This one has everyone talking. I want to show you the medicine that was allegedly slipped to her. Here it is. It's called misoprostol. He told his ex-girlfriend that they were vitamins and iron. These are all allegations, obviously. On one occasion, the victim received a call from someone purporting to be a nurse, stating her blood work showed she had an iron deficiency. And then on May 2nd, after a bout of severe debilitating symptoms, doctors confirmed the woman suffered a miscarriage. Per the detectives, the victim eventually spit out some of the pills, saving them in a Ziploc baggie. That was smart, but the damage obviously done. I want to show you some of the searches from Kawada's phone. Misoprostol discharge, 9-week aborted fetus pics. That's kind of sick. Telephone voice changer, criminal defense lawyer, should have looked that one up first, chewing misoprostol, no reaction to misoprostol, and iron deficiency anemia. And then he should have looked up criminal defense attorney again, one more time. Let's bring in our think tank, Meg Strickler, Molly Palmer, Josh Schiffer. Why isn't he charged with murder?
Why are you hanging him based on some internet searches? Because those are 10 searches out of the 50,000.
Are you actually defending this?
Yes, I got it. Come on.
Did you hear the allegations?
It's terrible.
Why isn't this a murder case?
It has a feticide. Why isn't it?
In some states, it would absolutely be a feticide.
I wonder if they don't have like a feticide in Massachusetts. And poisoning, if you look at the Massachusetts statute for poisoning, I don't know if it's exactly on point, right? So there's the question, of course, whether this is a horribly immoral, wrong, evil thing to do, but then like, is it illegal, right? That's a different question. And so poisoning basically criminalizes injuring or causing the death of a person. And I wonder, you know, in Massachusetts, where you can have an abortion legally up to 26 weeks and 6 days, does this create an issue for the prosecution? And I'm not saying, again, that this is not an evil, horrible thing that someone did. I'm talking about it from a legal
perspective. No, we're talking about, this is a very unusual case.
Poisoning. I don't know if it's a poisoning.
But she did have an injury because she had the miscarriage. That's not a fun thing to ever have to go through.
They have to define then the injury as a miscarriage.
Yeah. Because they're not, I haven't met a single human being who would not call that not fun.
Yeah, and I can tell you that in most states that have a fetal heartbeat the law enforcement would be rushing to charge them with feticide because that's a charge that's going to upset every juror just from moment one.
Yep.
Well, I think you put this in front of a jury, they're not going to like this much.
Off he goes.
And you have assault and battery, which is far more broad, and it's a specific kind of assault and battery. It's assault and battery against a pregnant person, which comes with very severe penalties.
Yep, vulnerable victim.
And there's actually additional charges involving, you know, tricking people using fraudulent food. There's a whole bunch of different things they can pile on.
Yep.
Now, they were in court today, and there were some arguments about getting a continuance and trying to, you know, push the case forward. But I want you to take a listen to all of this because some other things are brought up in these arguments.
Commonwealth has levied some pretty serious charges against Mr. Kawada. It's my understanding at this point, they don't even have medical records that they've produced or that they've even asked for at this point. They're charging my client with poisoning. And I frankly don't know how they can make those allegations with no medical records. But here we are.
Well, I don't know, right? I mean, perhaps there's admissions. I have no idea. But I assume, is this something that you intend to indict through the grand jury?
It is, Your Honor.
So, considering that grand jury investigations, right, are not public, I don't know what they have or what they don't have.
But Judge, we're here today, ready.
I understand you're ready, and I understand you're likely objecting then to a continuance. I'll hear from the Commonwealth.
Thank you, Your Honor. And as Your Honor's already alluded to, there is, the Commonwealth is utilizing the grand jury to investigate this. There's additional investigation that needs to be completed. As Attorney Scalia was already alluded, these are very serious allegations against Mr. Kawada. The Commonwealth takes that allegation very, very seriously, and as such, we take the investigation very seriously. I'm asking for additional time so that we can complete that investigation through utilizing the grand jury necessary information relative to the charges that the Commonwealth has brought against Mr. Kawada. This is the first probable cause date. Mr. Kawada is not in custody at this point. So I'm asking for an additional probable cause date so that we can provide that additional information obtained through the use of the grand jury and come back before this court either with indictments or an update as to the Commonwealth's investigation.
All right, so they want to push that probable cause because they're going to bring it to the grand jury. And if I recall, that would make the probable cause relatively moot.
Yes.
Correct?
That's exactly it.
So you'd rather have the grand jury, as a prosecutor, take a look at this rather than a judge.
Yeah, that's the whole thing that's going on here. It's because, you know, the defense is excited to kind of break down the elements of the offenses as charged in the warrant and say you don't have probable cause for these specific offenses based on the fact that you haven't proven a poisoning to this level. But the Commonwealth, of course, would rather have an audience of jurors to make that decision, maybe be moved by their own emotion, than they would have a judge actually look at the code and the elements.
We love preliminary hearings. We love probable cause hearings. They're the same thing because we try to use them as discovery. So we get the investigator, the detective, or the agent, whoever it is, on the stand, and then they're on the stand saying whatever it is, and then they're locked into whatever they said. So we love them.
And that's really the key point, is it's your opportunity as an aggressive defense attorney to lock them down into what they really are going to say now before they've had an opportunity to get reschooled by some of their colleagues or re-amend their memory. That contemporaneousness is key.
So we're really at the beginning of this case. We're not anywhere close to a trial at this point. This is in the district court. They're going to get rid of it. The grand jury may or may not indict. I think they will. But depending on what they will indict for, they could up the charges. Maybe they up the charges based on the investigation. And then they'll be back in. What do you think of this defendant, just the way he presents himself?
He doesn't present himself well, but I mean,
because I'm
people, already biased.
I just want to say, when people looked at him first, people were like, oh, he's not a bad-looking guy.
Good-looking dude.
Well, I mean, how you look does matter in the court of law. It's
He looks
doesn't
He looks younger than 40-something. I was surprised when you said 40-something. That's about all I say. But I mean, just the storyline made me personally biased, and I'm a defense lawyer. I shouldn't be biased, but when I hear this kind of stuff, this just seems extra and above and beyond horrible.
I mean, like, how good-looking do you have to be to get around those text messages? I don't think he's gonna. You know, it's not him. So
I don't know. I watch a lot of reality television, so there's some big questions at play right there. Being a good-looking person. Remember that model inmate from a few years ago with his?
How about Scott Peterson?
Exactly.
Right. I mean, it only gets you so far. I think it matters. But after a certain point, it's not going to be the game-changing factor in a criminal
And what
case.
do you think overall about the nature of this case? Because it's a very unusual one.
One of the easiest cases to raise the passions of a court and a jury that I can imagine. I can't think of something that would affect any parent, any person, anybody. You're trying to literally violate the most core sacred innocentness out there.
So you try and get a jury of child-free men.
Yeah.
Either
that, angry, childless women that would understand.
Does he tell his story?
lovers.
Does he have to tell his story?
Does he have to take the stand? I would advise him not to take the stand. There's no story for him to tell.
What if the defense is, listen, she did it herself?
Isn't it true you made the search of whatever you just showed those searches are? How do you explain that?
It's one thing to put up an alternate theory, but you have to have something. Like, you can't just make up something completely.
What would he say?
She gave the pills herself and then spit them out and put them in a bag.
There you go.
I was trying to give the kids superpowers. Like, it's my own Marvel origin story. No, man.
Plead the fifth.
You're going to have a struggle.
All right. Well, I'm looking at this case, and the first thing that struck me was, why are we not talking about murder? But now we've got the grand jury. Maybe they'll look at it a little differently. Maybe there's some scientific evidence about how old the child was, how long the child had been there. And that's something that I think is a little bit deeper in this case. Does this case, when you're trying to pick a jury, have anything to do with how people think about abortion?
Oh, God, that's what you're saying about the volatility of the topic. Both ways.
But in which way?
In both ways. You're bringing up is a fetus viable at 10 minutes, 10 weeks? You know, that brings up all that discussion. So when you're doing voir dire...
And to put on my most clinical criminal defense attorney hat, that's where you can divide the jury.
Yes.
Because regardless, you can use the idea and discussion of abortion to divide people. It's one of the most polarizing things out there.
It is, but
if the state makes this case about abortion, it's a lot easier for the defense at that point.
I don't think they are. I mean, they're not. But to me, I look at it that it's both sides. I would think would be angry. On the one side, people who are anti-abortion, right? Pro-life people.
Then
They're going to be outraged by this, right?
Yes.
But by the same token, I would think people who believe a woman should control her own body are going to be outraged.
Yes, because it wasn't her.
It's not her.
It's a betrayal of trust.
So to me, this is a lose-lose for the defense.
When you do voir dire, when you do the questioning of your potential jurors, you just want to get them talking, right? And so that is what this is going to look like in practice for this trial. You are going to have everybody in that courtroom discussing their deepest held beliefs on abortion, just to hear what they have to say.
And talk about rich pickings for trying to strike people. You're going to run out of strikes real quick in that
All
jury.
right. Great job today, Meg Strickler, Molly Palmer, Josh Schiffer. Appreciate your time, your insight, and your expertise.